Good afternoon. This is the Senate Judiciary and Public Safety Committee. And for the record, this is Tuesday, March 19th, 2019. The agenda today are two bills by Senator Dibble regarding data privacy. And we will be laying over each bill for possible inclusion in the Data Practices Omnibus Bill that we are creating this session. We're going to start with Senate File 1432. Senator Dibble.
Thank you, Mr. Chair and members, for the opportunity to present Senate File 1432, which pertains to employees, social media, employee and applicants' social media, and providing some more privacy aspects in relationship to employers or potential employers. Mr. Chair, I do have an author's amendment. Do you want to start with that, or should I proceed with the outlines of the bill itself?
Let's present the author's amendment.
Okay,
Senator.
great. So I would like to offer the A1 amendment.
The A1 amendment. Is the A1 amendment in our packages? No, so we'll have it passed out. Yeah. Senator Pappas, would you move the author's amendment for Senator Dibble?
So moved, Mr. Chair.
The A1 amendment is before us as an author's amendment. All those in favor say aye. Aye. Opposed? The amendment is adopted. Senator Dibble.
Thank you,
Mr. Chairman.
Senator Pappas.
It appears to me I don't have either of the bills in my packet.
Oh.
Somehow I have
Well, we'll get those to you right
nothing.
away.
Thank you.
Is there anyone else that's missing the bills or amendments? Hearing none. Senator Pappas, it must have just been you. So don't take it personal. Senator Dibble.
Thank you, Mr. Chair and members. So, Mr. Chair and members, we are aware, of course, that many of our civil liberties and protections aren't necessarily fully operational or in existence in the context of our employer and employee relationship, because, of course, when we're at work, while our time is being paid for, we are subject to some limitations and restrictions on those liberties and freedoms. We're expected to devote our time and attention to the job. We're expected to carry out the job in certain ways. We're expected to adhere to certain performance standards, our appearance, professional demeanor, making good use of employers' resources and the like. However, I don't think what most of us or any of us contemplate is that our employer or potential employer can reach into all facets of our private lives and our personal sphere. We wouldn't expect, of course, our employer to be able to walk through our homes and rifle through our personal and private possessions, or take a look at our private documents in our files at home, or look into other matters of our own private lives that in no way materially affect the performance of our responsibilities. But it has been, surprisingly so, the practice of some employers to demand to look at the private elements of employees or potential employees' social media accounts, which is a level of overreach that is, in my opinion, and others as well, unnecessary, overbearing, and inappropriate. So this bill would seek to limit that access to individuals' private social media accounts as employees or as applicants. So very quickly, in high-level summary, what the bill would do is it would prevent an employer from requesting information that would allow it to access the non-publicly posted aspects of an employee or applicant's social media account, or force that person to open up their account in front of an employer or potential employer, or force that person to name the employer or the boss or an agent of the employer as a friend or a key contact, or authorize an authorized agent of the employer to be named as a contact in a way that would allow it to monitor the private, non-public aspects of their social media account. The employers, of course, cannot threaten any action or refuse to hire an applicant to compel those things to happen. It does continue to allow employers to look at anything that's publicly posted, of course. It's considered a best practice. Take a look at someone's Facebook profile to see what they have out there. Allow employers to, of course, comply with the law. It allows them to request or require that things do be shared with them if they've received a report to make sure that the law is being followed, to make sure that the employee hasn't taken data or information or other kinds of property that belong to the employer, to investigate an allegation of harassment. And in a few minutes, we'll talk about that. We might need to expand that provision just slightly or significantly so to get to issues beyond harassment. It does make sure that the employer can restrict the use of personal social media for business purposes, and of course make sure that the employer can continue to disallow the use of social media while on the job or making use of the employer's equipment or resources or property in another way. It allows for ensuring that the employer is not in violation of these requirements if access to the username or password is inadvertent. That's fine, so long as it's not then used by the employer to log in and do a little looky-loo. A private right of action is provided for if the employer or potential employer violates the provisions of this new requirement, and there is a severability clause at the end there. So that's the overview of the bill, and Ben Feist is here from the ACLU, who assisted in the conception and construction of this proposal, who has some testimony.
Mr. Feist, welcome to the committee. Would you identify yourself for the record?
Mr. Chair, members of the committee, my name is Ben Feist. I'm the Legislative Director with the ACLU of Minnesota. Thank you for hearing this bill today, here in strong support of Senate File 1432. Over the past several years, there's been a strong bipartisan consensus that we need to update our privacy laws and Minnesotans' control over their personal privacy to bring these digital privacy laws into the 21st century. We believe that every person should have the right to decide who they want to share personal private information with. Privacy is not about keeping secrets. It's about maintaining control over our lives. Today, Minnesotans are as likely to use social media or other personal online accounts to communicate to a selective audience as they were to use a telephone a generation ago. This popular forum for the exchange of ideas and personal information will be compromised if employees and prospective employees know they may be forced to provide employers with access to these personal accounts. This bill creates an appropriate balance by prohibiting employer access unless one of the reasonable exceptions applies, as Senator Dibble has already gone through. So with that, we ask for your support today, and I'm happy to answer any questions.
Thank you, Mr. Feist. Senator Dibble, before we get into questions, answers, or others, you explained your bill, but I don't believe you explained the A1 amendment portion that has been adopted. So could you explain the exception that requires?
Yes. So this exception was requested by the Minnesota Police and Peace Officers Association, MPPOA, Mr. Dennis Flaherty, who's here, and it would create an exception for the purpose of conducting background checks for those who are applying for jobs in law enforcement, which seems like a reasonable exception. If it's limited, I think we could probably dream up all kinds of exceptions for all kinds of jobs, so I'd be a little reluctant to go too far down that path, but it seemed, first of all, it was being requested by law enforcement for the purpose of hiring within law enforcement agencies. So that gave me some comfort. Secondly, I can construe a rationale and a logic given that law enforcement officers have unusual authority, power, and duties and responsibilities vis-a-vis our personal lives. And so to hold them to a somewhat higher standard would seem appropriate in this instance.
All right. Are there any questions? Senator Hall.
Thank you, Mr. Chair. And Senator Dibble, this seems to be a good bill here. I do want to make sure I'm clear on the request from the police departments. Their request would be to ask for permission from the person that they're interviewing to do a background check and get into their private information. So the request is to ask for permission not to go into the private information without the hiree to being told or asked about.
Senator Dibble.
Mr. Chair, at this point, I will phone a friend and ask Mr. Flaherty to come forward and respond to some of the particularities around the intent of the A1. But I will say I agree with the spirit of the intent of Senator Hall's question. Yes, I think that's what I would hope as well.
Mr. Flaherty, would you identify yourself for the record?
Mr. Chair and members, my name is Dennis Flaherty. I'm Executive Director of the Minnesota Police and Peace Officers Association. And I'm here today in support of the amendment that Senator Dibble was kind enough to advance. Backgrounding of candidates is probably the single most important thing that needs to be done in order to ensure or to do the best that that can be done to ensure that hirees certainly are of the integrity and principles and morals and so forth. And one of the major ingredients of a background over the last, say, probably 10 years has been looking at an applicant's social media. It is a true snapshot into the individual, and it gives great insight into perhaps who they friend, causes they support. Perhaps they might be displaying some racial tendencies. Perhaps they may be, there's just any number of things. Anti-gay groups, jokes that people share, just things that really do illustrate the type of character of the individual. And it's really done one of two ways. Either they say, give us your password for your accounts, or they say, let's sit down and open up your various accounts. Either way would not be compliant with this bill. It would go directly at odds with this bill, and therefore that's why this amendment is critical. It's very narrow. It's drafted only for law enforcement agencies defined in statute for the purpose of hiring. For conducting investigations on applicants for employment.
Fuller?
Senator Hall.
Thank you, Mr. Chair. Mr. Flaherty, good. That's what I was hoping it would be. Can I also ask you, otherwise, you would not be able to go into somebody's private Facebook pages unless you had a warrant, I assume.
I would think that
Mr.
would be
Flaherty.
the only way you could gain access to it.
Okay.
Well,
Senator
stay
Ingebrigtsen.
tuned. We'll have more conversation about warrants in the next bill.
Senator Ingebrigtsen.
Thank you. Thank you, Mr. Chair. Mr. Flaherty, would this include conservation if conservation officers, although they are licensed peace officers? How about correction officers, both county or the state?
Flaherty.
Mr. Chair, Senator, no, as written, it would not include employees at correctional institutions. It would certainly, it would apply to conservation officers or any licensed peace officers.
Senator Ingebrigtsen.
Mr. Chair, thank you, Mr. Flaherty. And I know there has been talk of that, maybe even a bill floating around with that, with the idea of doing backgrounds for corrections officers. I guess, frankly, I didn't realize that we didn't allow that. So I don't know what the wishes of the group is, or Senator Dibble's thought about that, or anyone else thought about including them. Maybe it would be too big of a deal to do that here on the fly, Mr. Chair. I'm wondering what your thoughts are.
Senator Ingebrigtsen, we're going to lay this bill over for possible inclusion in our data practices omnibus bill this year, so we can continue furthering this discussion as we progress. Senator Dietzig?
Thank you, Mr. Chair. And so I briefly perused it, and it might not matter, but does employee include if you have a contracted employee? So I'm working for a staffing agency. So I'm technically not an employee of the place I'm working. I'm a temp. How does that prohibit the employer for doing certain things?
Senator Dietzig, you're back on the bill, not
Correct,
the
not the
A1s
amendment. Sorry,
necessarily.
yes.
So
Sorry.
Senator Dibble, any comment?
Thank you, Mr. Chair. I'll ask Mr. Feist to help me if I get this wrong, but certainly I don't think the bill as written covers a contractor. It doesn't really speak to the employer-contractor relationship. Of course, if the contractor is an employee of a larger firm, then at the point at which it became an employee of the firm under which the employee is working for a different organization in that contracting capacity, then of course they'd be protected at that first step. I don't know that they're protected at the second step, so it's an excellent issue.
Mr. Chair, just something to consider, because I think thank you, Mr. Chair, as more people become contracted employees in certain entities, I mean, they work for one agency that is then contracts with a business to do certain work. It might not be under like the application process, but for other instances, and then maybe even at the application process, just something to consider while it's laid over. Does that need to be added in here?
Thank you.
Senator Ralph, then Senator Pappas.
Thank you, Mr. Chair. Just a couple of details, I think, more than anything else. In subdivision 2, we talk about the employer access is prohibited, and then we talk about on line 217 and 218. The question I have is, what if and I notice there's something further in the bill that seems to address it, but I want to make sure we're covered here. It says change the setting affect a third party's ability to view content of a personal social networking account. What if the employee is actually using the business's equipment, computers, or other access to the social media? Have we considered how this works in with that? Because at that point, the employee is exposing themselves to the access of the employer's equipment. And have you considered how that plays into this bill? I'm not asking, to change it. I'm just asking what your interpretation of is how this would relate.
Senator Dibble.
Thank you, Mr. Chair. Senator Ralph, I'll answer in a couple of ways. One is, of course, the employer there's nothing that stops, and in fact, in this language, an employer's right is affirmed to prohibit an employee from using personal social media on work time, with work equipment, et cetera. And if in fact the employer's access is inadvertent, as you alluded to, and they do come into possession of the username and the password, they're not in violation of the provisions of this, and or are exposed to some of the information as well. So if the access is inadvertent through the mechanism that you just described, they're not in violation. However, they're not thusly empowered to go roaming around in that person's social media account and seeing what they can see and finding what they can find. They have to exercise some level of restraint and or delete that information as soon as possible.
Sir Ralph.
So there is no prohibition, though, from the employer going in once that password has been given to the, or has been allowed to be accessed by the employer, that the employer then could, I assume, access that account?
Senator Dibble.
Mr. Chair, Senator Ralph, no. If you look at lines 3.25 to 3.27, the employer is not liable for having the information, and that, that has to do with, using the employer's network, employer-provided devices, et cetera. But they may not use the information to access the personal social media account of the employee or applicant, may not share the information with anyone, and must delete the information immediately or as soon as is reasonably practicable.
One more follow-up, or one more question.
Sir Ralph.
Thank you, Mr. Chair. On line 3.16, it says the employer is permitted to prohibit an employee or applicant from using a personal media account for business purposes. What business? In other words, let's say you have an employee that also has their own part-time business on the side. It seems the way this is written, that might be interpreted to interfere with that. I guess I just think maybe there's a need for some clarity there. I don't think we need to solve it today, but I'm just pointing that out. It seems like that's a little overbroad and needs to be narrowed. I assume the intent is not to be used for business purposes at the employer's business, and so maybe that needs to just be clarified a little bit.
Senator Dibble.
Thank you. And yeah, we'll try to be a little more precise with that language. The intent of 3.16 and 3.17 is to prohibit the employer from requiring the employee to use their personal social media account to further the interests of the employer. So, for example, on my own Facebook account, if I work for Dairy Queen, I can't advertise a Dairy Queen Blizzards is the best deal in town they can't require that. I mean, I might want to do that because I love Blizzards, but the employer can't make that a condition of my employment, that I use my own personal Facebook to advertise Dairy Queen's Blizzards.
Senator Pappas.
Thank you, Mr. Chair. Just another follow-up on the question that Senator Dietzig asked on 1.11 and 1.12. It seems to me that this definition is broad enough to include contracted employees, and I'm wondering, is that the author's intent, and if Mr. Bacchus wants to weigh in.
Senator Dibble.
So what is, yes, Mr. Chair, I think, I didn't catch that, and I appreciate your eagle eye. Would Senate Council concur?
Ms. Primo.
Mr. Chair and members, the definition is broad, but I will have to consult with counsel for jobs on this one, since she likely has the expertise on whether this captures independent contractors.
Great, thank you.
And Mr. Chairman?
Senator Pappas.
Just hopefully that it's the author's intent to include independent contractors.
Senator Dibble.
Yes, Mr. Chair, that is my intent. Thank you, Senator.
Are there any other discussion or questions? Is there anyone in the audience who wishes to speak for or against this bill? Welcome to the committee.
Mr. Chairman and members of the committee, my name is Tony Quillis, and I'm testifying on behalf of CompTIA, which is the Computer Technology Industry Association. And just wanted to touch on one point, Mr. Chairman, and I want to thank Senator Dibble and Mr. Feist for having some conversations with me about the concern I'm going to bring to your attention, and pledge to keep working with them, because I know you're going to lay it over for possible inclusion, and pledge to keep working with them on my concern that's in the bill. But, Mr. Chairman, it has to deal with on line 2.1 of the bill, as username and password bills have been moving across the nation. 2013, 28 states looked at it. In 2014, another 18 states looked at it. So as this was being debated among state legislators, the Uniform Law Commission looked at legislation that was moving among all these states and came up with some recommendations on language to provide clarity and stability and consistency for individuals and businesses across state lines. And the recommendation they came up with was...
Excuse me, Mr. Chair. I think we're looking at lines 2.11.
2.11, thank you, Senator Dibble.
Yeah.
Thank you,
Yep.
Senator Dibble, for
Mr.
clarifying
Quillis?
that for me. And instead of saying username or password, it would be username and password. And Mr. Chairman, I'll get to an example about that in a second, but that was a recommendation from the Uniform Law Commission. And at least in some of the Midwest states, I have pulled up Wisconsin and I pulled up Illinois, and both of their laws that they just recently passed included username and password, not or password. And I think that if you look at the exemption that we've been talking about for inadvertent access in subdivision 5, where an employer inadvertently receives username or password, I think it's through the use of an otherwise lawful virus scan or firewall, not just an inadvertent access by the employee. So I just wanted to point that out, Mr. Chairman, because here's the example that I'm going to use. If I applied for a job at XYZ Hospital, or if I apply for a job at Acme Machine Company, and I write down my name, Tony Quillis, I just gave you my username. My username for my accounts, for my Gmail account for Comcast is tonyquillis@gmail.com or tonyquillis@comcast.net. I just gave you my username. So that explains why it's username and password, not username or password. So it's just a clarification, like I said, Mr. Chairman, to try and provide some clarity and stability and consistency between states. And I wanted to point that out for the committee's consideration. Like I said, I'm going to pledge to keep working with Senator Dibble and appreciate the time he spent with me and Mr. Feist on this issue, but wanted to point that out for the committee's consideration, Mr. Chairman. And thank you for the time.
Mr. Quillis, is it possible to gain access to a personal social media account with just a name?
Good question, Mr. Chairman. That's
because
why,
if we include the word "and," then it doesn't apply.
Mr. Chairman, I think we're trying to provide the clarity, like I said, from that the Uniform Law Commission has recommended to provide the clarity and the consistency. But I think by providing you, clarifying that it's username and password, not just username, because you would provide the username when you would apply, Mr. Chairman. So therefore, reading the law verbatim would be username. If the inadvertently is supplied to the employer, you would supply it in the example that I used. Mr. Feist and I have had some conversations about how to address it. It might not just be the and or it might be a different proposal at Mr. Chairman, and that's why we're going to continue these conversations.
All right. Thank you. Is there any other discussion or questions?
Mr. Chair.
Senator Dibble.
Just wanted to respond quickly to Mr. Quillis, and I think Mr. Feist has a response as well. We will continue to work together. I think the critique and the complaint is a little bit nitpicky, and I think perhaps, and I do think it actually opens up, conceivably, a back door to getting into people's personal, private social media accounts in ways that clearly is not intended by CompTIA, because their letter is quite clear that they want to comply with the intent of the bill. So we probably just need to come at the critique from a slightly different direction, but we'll continue talking.
Senator Dibble, I don't think any of the members of our committee have a copy of that letter. We'd be interested in seeing that also, if you could provide it.
Mr. Chairman, I'd be glad to provide that.
All right. Mr. Feist, did you want to make comment on this?
Mr. Chair, briefly, yes. The concern that I have is sort of on a loophole level here, where if an employer already has, for one reason or another, a username or a password, then under this law, you would be able to demand the piece that you're missing as the employer. That's my concern, and why I think we need to have it as or.
Okay. I did ask if there were any other questions. I didn't hear any more, but I do have one. I'd like to play the devil's advocate. We have an exception in the A1 amendment allowing law enforcement to investigate the background of an applicant. And the reason was we want to know who that person is. Do they have any opinions, let's say, that might be damaging to their profession? But isn't that just as important for a corporation to know if an individual has presuppositions over how they relate to certain racial groups, how they react to different, perhaps they have prejudices of their own. Corporations, if they hired someone to that effect in a key position, they could be sued as a corporation. Why is it important for law enforcement to have the exception, but not a corporation that's hiring someone that may put them into a liability? Senator Dibble?
Thank you, Mr. Chair. It's an excellent question. I was a little reluctant to take in the A1 because I knew we'd go down this rabbit hole. But I do think that a key difference between an employee of Corporation XYZ or Acme Machine Company is that police have unique powers and authorities and responsibilities. One of them, of course, is investigatory power. They can do the deep dive and look into our personal data, hopefully with warrants and things like that. But nevertheless, they have that power and authority. So, making sure that they're themselves subject to similar standards is appropriate. Secondly, police, of course, are uniquely positioned in our society to be able to use force. They have, the ability to back up the power of the law with physical remedies. And that is a unique and awesome power reserved to police. And so to make sure that we're hiring people who are of the highest standard with the utmost scrutiny is extremely important.
Senator Dibble, I was just thinking of if I owned a corporation and it was a PR firm and I had access to someone, an employee applicant's social media account, and I found out that that individual was a supporter of David Duke for president, would that be an important element for a corporate leader to know, or does it not count? And that's always the rub when we get into these types of discussions. How far do we go? And
Right.
and I don't have a clear answer myself.
Well, Mr. Chair, that's
Senator Dibble.
why we're paid the big bucks. We find out, I like the metaphor that I use is that in transportation, we have this discussion about what is the appropriate speed limit, and we have to make a judgment call and strike a balance. If 80 miles an hour is less safe than 70 miles an hour is less safe than 60 miles an hour, well, 20 miles an hour, 15 miles an hour, that's really safe. So, why don't we just make sure that everyone drives 15 miles per hour everywhere all the time? We'd have hardly any accidents. It would be great. So we have to make those judgment calls. It's hard to do. On your David Duke question, again, judgment call for a corporation. On the other hand, it's a free country, and we have prohibitions against discrimination on the basis of values and beliefs, et cetera, within certainly Minnesota law. And getting back to the law enforcement question, would we think that it's permissible for an employer, like I said in my opening comments, to walk into our house and rifle through our private filing cabinet in our home office. Probably not. And so that's the kind of parallel I'm trying to draw with our personal electronic information. Will be part of the conversation in the next bill as well.
Mm-hmm. Senator Dibble, you and I have had discussions about this bill in particular, and I like the general direction it's going. I'm just throwing out these questions that someone else on the Senate floor is going to be asking you and me. So
I have no doubt.
It's good to prepare for it. I don't believe there's any further discussion. This bill will be laid over for possible inclusion in the
Mr. Chair,
omnibus data practice. Yes, Senator Dibble.
I did want to mention that Management and Budget, MMB, did bring up the issue of lines 3.14 and 3.15, confining one of the exemptions that allows an employer to take a look at this personal content if they upon an allegation need to investigate unlawful harassment in the workplace. And we had a good conversation this morning in my office about how that might be a little too restrictive, and in fact we should change that language to something like investigating violations of workplace policies or something like that. Because of course we think of government as a regulator, as an authority, and we think of ourselves as civilians, but government is also an employer and an enterprise. And so if we restrict its abilities to investigate workplace issues, then we might have
Senator Dibble,
might be an overreach. So we're going to work on that language a little bit.
I can also think of cyberbullying also that it might fall into in the workplace environment. Senator Anderson.
Thank you, Mr. Chair. Senator Dibble, was there a fiscal note prepared for this at all?
Mr. Chair, Senator Anderson, no, I'm not aware of a fiscal note.
Is there any fiscal impact from council?
We do not have our finance counsel in the room right now. I have not been told there is.
Okay. Just
At
wanted
this
to
time.
ask the question. Thank you.
But again, we'll be laying this over for possible inclusion in the omnibus data practice bill. We're going to move on to Senate File 1431. Senator Dibble.
Thank you, Mr. Chair and members, for the opportunity to present Senate File 1431. And this bill is termed the Minnesota Electronic Communications Privacy Act, ECPA for short, Minnesota ECPA. And the idea of this bill, Mr. Chair and members, is fairly simple and straightforward. Even though it's a longer bill, more pages, it seeks to treat our electronic property the same as we would treat other property, including our written documents and materials, free from unreasonable searches and seizures. Everyone, of course, is aware of the Bill of Rights, the first 10 amendments to the U.S. Constitution, the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Because, of course, the founders believed that freedom from government intrusion into one's home was a natural right and fundamental to liberty, and so included that provision in the Fourth Amendment as a part of the Bill of Rights, the first 10 amendments. And if we look at the Minnesota Constitution, the exact same language is in our Bill of Rights, which is enumerated in Section 1, and there are 17 sections that comprise Section 1 of the Minnesota Constitution. And the prohibition on unreasonable searches and seizures is Section 10 of our Bill of Rights. So the bill itself, it creates a new framework for protecting Minnesota's privacy in the digital age. And it provides a reasonable privacy for protections of emails and other electronic information where federal law has failed to do so. It requires law enforcement to obtain a search warrant based on probable cause in order to access digital information, which would include content, location information, metadata, which is kind of information about the information or the device, and device searches themselves. It specifically addresses a loophole in federal law, which is reflected in Minnesota law as well, in which law enforcement can access emails that are more than 180 days old without a warrant. So it would, this new bill, if passed in law, would say that if we're going to access anyone's email, you need a warrant to do so. I'll repeat that. If you have an email that's sitting out there that's more than 6 months old, law enforcement can just go help themselves to reading that email. I think most Minnesotans would be pretty shocked to know that's the case and would reject that power and authority of law enforcement. It does include exceptions for law enforcement in the event of emergencies or other public safety needs. It has provisions that contain requirements for notice, for reporting, and for enforcement provisions to ensure that there is transparency, oversight, mechanisms to make sure that the law is being followed. So that's a very, very high-level overview of the bill, which is 8 pages long. I can go into more detail if the committee so desires. But I do have Mr. Feist, who's here, who can also provide more information and some testimony.
Thank you, Senator Dibble. We have 4 people who wish to give testimony on this bill. Mr. Feist, followed by Captain Bianconi. So, Mr. Feist.
Mr. Chair, members of the committee, again, Ben Feist, Legislative Director with the ACLU of Minnesota. Also here very much in support of Senate File 1431. We support this bill because it provides a strong new framework to update Minnesota's privacy laws for the digital age. While the legislature has grappled with certain technologies and technological advances over the years, many of our existing statutes regarding electronic communications are still based on law from the late 1980s. And this can be very difficult then to track whether it really meets today's expectation of privacy. Existing privacy laws in other areas typically require the police to get a warrant before searching the file cabinet or computer in your house or the letters in your mailbox. Now that technology is advanced, state law needs to be updated to require the same warrant protections when the police want to read your emails, text messages, or other digital documents. Nearly all of us rely on mobile devices and the internet to connect, communicate, work, manage our finances, and research information, including on sensitive topics such as politics, healthcare and treatment, and organizing for social change. Minnesota residents should not have to choose between using technology at all and keeping their personal lives private. This bill is based on a model that drew support from both advocacy organizations like the ACLU and many in the tech industry. Tech industry in particular has an interest in uniformity through the states. So specifically, this framework was originated in California, known as CalECPA, and we recognize that in the process of trying to adopt that framework for Minnesota, we might have created some unintended consequences or conflicts with existing state law that still need to be addressed with stakeholders in law enforcement and other government agencies. I imagine you'll be hearing those concerns from the testifiers coming up, but I do want to say on the record that we have been engaging in discussions with ways to narrow the scope of the bill so that we can create the type of privacy protection that we really want to have without going too far and creating problems that, again, we don't intend. So with that in mind, I do expect that we'll have amended language the next time the bill comes before this committee, and we will continue to work with all the stakeholders to make sure we get something that's reasonable.
All right.
Thank you.
We'll move on to Captain Bianconi. I hope I'm pronouncing that correctly. And then we'll followed by Deputy Commissioner Lee Ho. Department of Revenue. Captain, would you identify yourself for the record?
My name is Dan Bianconi with the Dakota County Sheriff's Office. I also I oversee our investigations division with the Sheriff's Office. And
could you pull that microphone right in front of you?
And the Electronic Crimes Task Force as well. The Electronic Crimes Task Force deals with the processing and handling of digital evidence. Mr. Chair, members, I appreciate the opportunity to speak. As Mr. Feist has indicated, we have been in discussion, and I think there's certainly some areas that we can work together on. I'd like to spend my time with you today just outlining some of the concerns that the Minnesota Sheriff's Association, whom I'm representing today, has on this matter. Under line 4.8, specifically the 30-day timeline, under the subdivision 3, the warrant, the timeline pursuant to the warrant, it indicates that within 30 days, the data would need to be destroyed that's unrelated to the search warrant. And this is particularly burdensome as it implements a timeline that is very difficult for law enforcement to comply with. There are many reasons why it's difficult in a 30-day timeline, but the biggest thing is the volume and amount of data that we get in cell phones and tablets and computers to be able to go through that, and that 30-day timeline is very problematic. If we're to comply with a 30-day timeline, there's two unintended consequences that I see as a result, or basically an effect of that timeline implementation. It would result in us having to triage cases by looking at the severity of a crime, because we don't have the current resources to comply with that 30-day timeline for all crimes. The flip side of that is, otherwise, if to comply with the 30-day timeline, we'd need to not be able to identify all areas of electronic evidence in a case. In other words, we'd have to conduct incomplete investigations because we wouldn't have the time to process all of the digital information. Oftentimes, the data sought in a warrant and what's included in a forensic download of a device are commingled. So we may be looking for text messages about a communication pursuant to a burglary or a robbery or a homicide. But along with those communications between the same people can be information that is not going to be involved in our search warrant. So the 30 days is needed to manually go through and evaluate all of that data. There is no find evidence button as much as we'd like to have. That technology does not exist. Under 4.15, the appointment of a special master. The special master requirement removes law enforcement discretion from an investigation, and the analysis of the investigative data depends on the discretion of the technical competence of the third party. So a forensic examiner would download that data, turn it over to a special master. The special master's job would be to evaluate that data and see what is applicable to the nature of that search warrant or that crime. And we believe that that discretion belongs with the role or job of a detective or investigator. As a result of that, the skills and the training that's developed over years, perhaps even decades, for our forensic examiners, those skills aren't going to be used to conduct as thoroughly and high-quality investigations when you turn that over to the role of the special master. The decision about what relates to an investigation belongs to the special master at this point. So their skills are going to identify that type of information relevant to our search. We have concerns that the appointed special master will not have the skills to understand the information they are presented or to be able to make the associations of the data that we seek. The appointment of the special master will also increase the time it takes to complete an investigation, as it generates an increased level of bureaucracy, another wheel in that process of an investigation. For all the same reasons that law enforcement struggles to complete these electronic investigations, the volume of data and the complexity of the data, the special master will have all of the same problems. From an operational perspective, this is concerning as the longer it takes to investigate a crime, the greater the challenge it is in achieving a successful prosecution. And the reason for that is witnesses and victims, generally speaking, become less cooperative the further they are from the time of the crime until the investigation is completed. We can lose track of witnesses, we can lose track of victims, or people change their mind. During this time, offenders are held unaccountable. Another area that's concerning regarding the special master is how investigations naturally expand. Currently, forensic examiners pursuant to a search warrant will examine devices that are detailed in an affidavit, a search warrant. When criminal activity other than what is described in that search warrant is observed or learned of during that review of the information, the home detective is notified of the discovered information and a new search warrant is obtained. With the special master, there's no indication in the bill that would require a special master to report discovered criminal activity. And even if they chose to do so, there's no guarantee that that person has the training and the competence to understand what age questionable child pornography is, to understand the elements of a complex fraud or homicide. Under Section 5.8, that is the emergency provision. This is concerning as it is a well-established exception to a warrantless search. This has been pretty well defined by the Supreme Court. I think there may be some misunderstanding on how law enforcement generally uses this location data, sometimes referred to as metadata, when concerning emergencies and location pings. More often than not, we're responding to a mental health crisis, a missing person, someone with dementia, someone who is in need of help. These are non-criminal matters. A search warrant is used to look for evidence of a crime. So even if we wanted to comply with this provision, a search warrant is used to look for evidence of a crime, and these examples I indicated to you, these are all non-criminal in nature, and a search warrant would not apply. The location data used in an emergency situation is often used to look at or look for juvenile runaways, missing persons, and a wide variety of people who call for help or who are in some type of other mental health crisis. I'm happy to take any questions, or we can turn it over to the next testifier.
Thank you, Mr. Bianconi. We're going to move on to Deputy Commissioner Lee Hole, Department of Revenue. And we're going to hold our questions until after everyone's given testimony. Mr. Hole, we'll get you a chair up in the front. And perhaps, Mr. Feist, you could leave the table for now. Thank you. Mr. Holt, welcome to the committee. Would you identify yourself for the record?
Thank you, Mr. Chair, members of the committee. For the record, my name is Lee Ho, Deputy Commissioner at the Department of Revenue. I'm here today to provide testimony regarding Senate File 1431 and what we believe are unintended consequences to the investigative work at the department. In 2017, lawmakers, including members of this committee, worked with the Department of Revenue to establish a felony criminal penalty for the sale, purchase, installation, transfer, development, manufacture, or use of a sales suppression device, knowing that the device may be used to commit tax fraud. As you might recall, this kind of device is sometimes known as a zapper and works to delete parts of a cash sales transaction after the sale has occurred. It creates a second set of books and allows a business to report smaller sales to the Department of Revenue and to illegally keep some or all of the sales tax that a customer paid when they made their purchase. This kind of software might be downloaded onto a device or accessed through a remote computer or cloud-based service. Earlier in May this year, we, along with the St. Louis County Attorney's Office, announced the first convictions of 2 individuals and the related business for tax crimes connected to the use of sales suppression software. During their plea hearing, the defendants admitted to intentionally using Zapper computer software that they referred to as Happy World. In this case, that software was discovered by the department's investigators during the execution of a lawfully obtained search warrant at the restaurant. Working with computer forensic specialists, the department was able to open the Happy World software and learn more about how it can be used. We are continuing to identify zappers like this one and work with our law enforcement partners and with the BCA to prepare these cases appropriately for felony level charges. As drafted, the scope of this bill is broad and includes the kinds of electronic communications that arise in sales suppression investigations. This bill could have unintended consequences in this area. For example, this bill disrupts current warrant standards that we carefully follow in our cases today. There are also many competing demands for computer forensic resources. Our Zapper cases are important to the best interests of the state. Sales tax altogether brings in about $6 billion annually to the state's general fund. Even so, Zapper investigations do not take priority over other criminal activities that have been described by other testifiers. Thus, the timeline constraints in the bill, including the 30-day timeline for destruction and the 90-day timeline on the sealing of a warrant under certain circumstances, are unworkable given the competing priorities for computer forensic and law enforcement resources. We appreciate the opportunity to testify and share our concerns. We also appreciate our conversation with you, Senator Dibble, before committee, and we appreciate the opportunity to contribute to any compromise language to protect privacy while ensuring law enforcement can work effectively. I'm open to take any questions you may have at this time or later.
All right. Thank you, Mr. Ho. We will be asking questions later, but we're going to move on to Mr. Drew Evans, Superintendent of the BCA. Superintendent, welcome to the committee. Would you identify yourself for the record?
Thank you, Mr. Chair and members. My name is Drew Evans. I am the superintendent at the Bureau of Criminal Apprehension, and I, too, wanted to testify today with concerns that the Bureau of Criminal Apprehension has in regards to this bill. I would note, as we work, the Minnesota Bureau of Criminal Apprehension works in partnership with our law enforcement partners across Minnesota on some of the most complex and challenging crimes as we work to disrupt criminal organizations across Minnesota. I would like to note, as the ACLU has said, we've had productive conversations about this bill, and I know the ACLU has been in contact with Senator Dibble. And we look forward to continuing to work on this bill as we look for ways to potentially compromise, as the BCA is open to clarifying and ensuring that the privacy interests of Minnesotans are protected while we work to ensure that we gather this evidence appropriately. I think some of the unintended consequences of the drafting of this bill, I would like to note for this committee as to just what our specific concerns are. I'll note as we go through, and I'll try to keep it fairly high level, but to just understand what those concerns are as we start looking at the definitions in lines 2.1 really all the way down to 2.14. These are definitions that have been taken from different provisions and then some new from different portions of our statutes. However, I'd like to note when they're used in this context, we think that it creates a very broad overarching definition of really all things when it comes to these electronic communications, which I do believe is trying to clarify a number of different pieces along the way. However, there are different search warrant statutes that we currently utilize. In the 626 statute, which is different than these provisions, these definitions are not there, and there's a number of things that we currently have to get search warrants for that would be encompassed in this, which would create confusion for our investigators as they're working in this. Again, and we don't want to create confusion as to which provisions apply this search warrant statute or the other one. As we move down to lines 2.31 through 3.2, this is a definition about specific consent. And really, when we look at this, one of my significant concerns as this reads in those lines is it notes that a government employee or agent must notify the other end of the originator of the communication that they're a government employee. I want to note for you that when we're conducting operations such as undercover chat operations where individuals are attempting to solicit sexual relations from minor children, for example, as this reads, I believe we would have to disclose that we're the government agency conducting that operation, which I do not think was necessarily the intended purpose of that statute, but I think it would create that consequence for us. When we're moving down to some of the exceptions under this, I think there's some drafting in 3.21 and a number of the provisions in here. When you look at line 3.21, it says a search warrant under section 626.18, which is the traditional search warrant statute. And I don't know if it's referencing subdivision 4 in this 626A or subdivision 4 in 626.18, but that's an indemnity clause. So I'm confused as to what the actual reference would be noting. And so we'd want to make sure that we're clarifying that piece there. The other lines 3.30 with specific consent to the owner only when the reported device is lost or stolen. I'll note for all of you, we do have cooperating witnesses, cooperating confidential informants that are working with us that do provide consent to us to utilize their communication devices in the operation of our criminal investigations, and we would like to see that possibility is there so that people that are wanting to be cooperators in our criminal investigations have the opportunity to do that, not only when it's a lost or a stolen device. Once we start moving down into the search warrant provisions that are outlined in 4.4, when we see this here, I now start seeing references to a search warrant under this provision. And what I think it's going to do here is start creating confusion for our law enforcement officers as to which search warrant provisions we're supposed to be using under this 626A or 626 when we're looking at that particular item. The first clause in 4.5 through 4.7, it notes that here you must note the specific time periods. And oftentimes we are required to do this by judges now looking for a specific time period. We do not have carte blanche access to all records. However, this broad definitions that I noted above would now apply to devices. And oftentimes when we're receiving tips on child pornography, exploitation of children online, we do not know the specific time frame for which we're looking on the device. We know when it was uploaded or it was sent via electronic communication. I have no problem being able to give a specific time frame there. But when we're going to search a person's house, which we'd normally do under the other search warrant provisions, we often don't know when that item would have been uploaded onto that particular device. And so this would provide such specificity that it would be hard to comply with in all situations. I would concur with the previous testimony about destroying the evidence within 30 days. From our perspective, as we're pursuing criminal investigations, I don't know how we could destroy any evidence, as we would consider all of it potentially exculpatory, and we want access to the defense team to review that. And I would be very nervous ever destroying any evidence while a criminal investigation is pending. In line point, the 4.12 through 4.14, again, this is a very broad provision where it talks about all other provisions of Minnesota and federal law. I think it's meant to be a catch-all so that we don't miss anything. But again, it creates confusion as to does the 626 statute apply, or should we be applying for warrants under these new provisions? I would agree with the special master. That is not something we really do currently in the state of Minnesota, so we would just look for some clarification as to what the special master would do and how that would work. The only real analogy currently is under wiretap law right now. The judge, when they issue a wiretap under our laws, does do review of the work that we're doing to make sure that we're staying within the confines of the wiretap statute. The 4.19 through 4.21, I think the most concerning line is 4.21. It says otherwise prohibited by state or federal law. Again, I would be concerned because of the very broad definitions that we see here, that things like the National Center for Missing and Exploited Children, they send us tips on suspected child pornography. I don't see an exception for something like that in this law, and so I'm not even sure they'd be able to turn over those tips to us based on the statute as written. Also, moving down to 4.22 through 4.24, Again, in this situation, it sets out another different timeline for destroying data. It would be much easier for us as government entities to comply with our normal data practices, retention schedules, and certainly we could look at how we might be able to do that. But when we have competing timelines for keeping data, keeping information we have, it gets very challenging for us to follow. Moving down to the emergency exceptions into 5.9, I would just note that involving danger, death, or physical injury, this is when an electronic communication relating to an emergency. I think that is a fairly broad definition. I think it covers most instances. I would ask that we at least consider other instances, such as a voluntary relationship between a minor, for example, and somebody that's overage may have taken the child. We may or may not be able to say that that person's truly in danger, but we obviously have concern for their welfare in that instance. And so we'd want to think about what that would look like. The other things in 5.11 to 5.13, I don't have concern about this language in terms of filing with the appropriate court the order after the fact. I will tell you, this isn't our cell tracking statute that you previously have passed in this committee. We've been trying to do this with judges, and the judges are refusing to sign the orders. They're telling us that you had exigent circumstances in those situations. If you have exigent circumstances, a warrant is not required. I will not sign it after the fact. And this is happening to us on more than one occasion. We don't have a problem from a law enforcement perspective. I'll just tell you that the judiciary has expressed concern about signing those orders after it has already occurred. The other piece on 5.20 is just the subpoena powers. I would just note this is now a new subpoena place here. We have two different statutes, or several different statutes, but the primary ones we work with are the county attorney's subpoena power and the attorney general's subpoena power. It's easier for us if we just leave those provisions, if there wants to be a tweak to those particular subpoenas, as opposed to having a separate subpoena provision in here. Moving all the way down to lines 6.9, 6.10 when it comes to the notices. I will note under the 626 statutes right now for search warrant, there really is a notice provision baked into that, because we have to provide a copy of the search warrant to the person, and if we are going to delay providing them a copy of that search warrant, there are specific provisions that already apply that we have to follow now as law enforcement to delay what is in essence notice under that statute. And so this again creates a different set of notice requirements when we're looking at it. The moving down to 6.33 and 6.34, the no identified target. Certainly, this is something. This is not any. There's no analogous notice that we do right now to the state Supreme Court. Certainly, from a law enforcement perspective, that time frame for partners that in a very large state across Minnesota, I don't know if that's something they could comply with on a regular basis. It's something we certainly could, but there is no mechanism in place right now to provide that notice to the Supreme Court, as it's not something we do. The other piece with that on line 7.4 with the notice, I will note that if these are in a search warrant, even though there's not a identified target, all of that information largely is currently public information, and it is now instructing the Supreme Court to redact certain names when it comes to that. Under the remedies provision, under the suppression, moving to line 7.10, it's our preference that the court already do a number of examinations. The exclusionary rule always applies. I know the ACLU and I have had discussions about this piece of this as to where that is. Our preference would always be that the courts follow their own rules and regulations when it comes to suppression. And then really lastly, from our perspective, is this petition piece information, 7.17 through 7.23. I am a little bit confused from our perspective as to what this means. I would hope that, I think the preference would be that certain information could be petitioned and the judge could require us to destroy that. I would hope that we would never be in a position where somebody could petition and a judge would be making decisions about an active criminal investigation where we have data that's necessary to our investigation, but the interplay of that particular statute or those lines I would have some concern with as well. And those outline our primary concerns with this bill. And again, I'd like to note we've had very good productive discussions with the ACLU, and I think we're working on a lot of the problematic pieces of this legislation from our perspective. Thank you.
Superintendent, I had one question. Do you have an opinion regarding the needing of a warrant after the 180 days?
Mr. Chair and members, so when it comes to this, so there is a provision that was pointed out to me today, 626A.28, I believe, is there's a number of pieces with the electronic communication. I will tell you, we're not using that provision. We're getting warrants for everything. I do agree, as I had a discussion before the hearing today with the ACLU, I think based on all of our current practices, there's some ways that we can clarify and perhaps narrow that information. I have spoken with all of our agents who do this type of work. They have not been able to get any communications over 180 days without a search warrant, even with that provision. But I don't think it hurts to clarify what the meaning of that statute is, even if it's clear that we cannot get emails over 180 days.
All right. Are there any questions? Discussion? Sir Ralph.
Just one quick question about procedures in non-data-driven cases, or non-electronic data, I should say. And maybe Mr. Evans, you could comment, but it seems to me that we're adding another layer here by adding the special master in. And I'm concerned by some of the other testimony that if that person is not experienced in forensic electronic matters, that, for example, I think the Department of Revenue's situation is a perfect example of this. Someone not totally familiar with the technical issues might not understand that. So we don't use a special master now to examine confiscated hard copy records. And so I'm wondering why we would, or how this might hinder your operations if we did in fact do this.
Superintendent?
Mr. Chair, Senator Ralph, I do think that it does add a layer that would complicate, as the other testifiers had noted, and I concur with them, that the special master would unnecessarily delay. If the concern is about protection of the data, I think that there's ways to do that to ensure that it's not released, as opposed to working through a special master each and every one. There are additional provisions, in law about businesses and ensuring that businesses have access to their records, for example, if they're not related to the ongoing criminal investigation. There are some guardrails in place already, but yeah, I think you outline our concern.
Senator.
Thank you, Mr. Chair. I think, and I'll ask Mr. Feist to come back up to help me with some of these responses, but the special master is not crucial, of course, to the operation of the bill and the intent of the bill. Nevertheless, it's there for a reason, which is, of course, an added layer of objectivity and transparency, in making sure that these examinations of our personal, private content aren't overly broad. And so that's the general intent of the special master. There's an assumption that the special master would bring some expertise with them.
Mr. Feist, did you want to add to that?
Mr. Chair, no, that's largely my understanding as well. And, if this is going to be a major hurdle for this bill, we can definitely work on that to significantly change it or remove it.
And just members, so you're aware, Mr. Backus and Mr. Feist worked late into the night trying to create a new document for you to look at and respond to, and that turned out to be a bridge a little bit too far to cross in that short amount of time. That being said, this bill's been around for 4 years, so there's been plenty of time. I'm just learning about a lot of this stuff in the last 24 hours. BCA has had plenty of time to surface a lot of this, plus it's received fairly thorough hearings in the House. So, we're being forced under the crush of time to scramble with what I counted 14 critiques from the BCA that we're just now confronting.
All right. Senator Anderson.
Thank you, Mr. Chair. Mr. Evans, you mentioned in line 4.9 about the warrant being destroyed within 30 days, and I'm just wondering, what is your policies right now as far as destruction of that type of...
Superintendent?
Mr. Chair, Senator Anderson, that's referring to the evidence. Currently, right now, all evidence that we gather in a case would be retained through the conclusion of that case and through any applicable appeals period, and then it would follow our data retention schedule, which varies based on the type of crime that we're investigating. So it can be a period of a short period of time to years, depending on what type of case it is. And then it is destroyed at the end of that retention schedule. And the reason for that retention schedule is to maintain that data. Again, so if appeals or others wish to challenge some of that evidence, that it's retained and available.
And Superintendent, how long do you hold that data?
Mr. Chair and members, it depends based on we have a very detailed evidence retention schedule that we file that outlines how long we keep that evidence and data, and it relates to the type of case. It varies whether it's a criminal sexual conduct or a homicide is how long we retain that data. And then it follows the data classifications under the data practices statute.
Could you give me a range of how many days or months you may keep that data?
Mr. Chair and members, it can be anywhere from 3 to, in a homicide case that's unsolved, through the duration for as long as that case remains unsolved. So it can be many, many years.
Senator Dibble.
Thank you, Mr. Chair. I think the destruction of data is, and if this is not clear, we can make it more clear, but the intent is to destroy property, private, personal property, that's been obtained through a warrant that is unrelated to the subject of the investigation or the purposes of the crime that's suspected and being investigated. So that's a different matter than preserving evidence.
Senator Anderson.
Mr. Chair, and to that point, I guess, as Mr. Evans has already alluded to, the fact that if a unsolved case is there, destroy that evidence there, you would want to be able to, I think of cold cases where people go back in and try to resume that after 10 years or 15, and too bad we have TV, but TV does give us some kind of indication that people, inspectors or investigators, have gone back in and been able to resolve cases, I don't know how long. But anyway, I guess that's a concern, I guess, because he brought it up. I'm just concerned that we might go too far with this. So,
Superintendent, when you're holding data like this, is there a separation between what would be considered confidential data by your agency versus private classification?
Mr. Chair and members, when it comes to this, while the criminal investigation is active, it's all considered confidential data. It's stored separately by case. For electronic data, if we have it, it's going to be either stored in a secure electronic case management system, our evidence room. As I said, it covers a lot, or we secure it on a very secure SANS server. It's a sectionized server that maintains by case number. When the case is closed, and I think this is part of what they're referring to, is that the information then would follow the Data Practice Act. Some of that information certainly would be protected data under the Act. Some of that information would be considered public under the Act as well.
Senator Dibble.
Mr. Chair, let me just read the language. A warrant for electronic communication information.
What line are you on, sir?
So I'm starting at subdivision 3, line 4.4.
4.4.
A warrant for electronic communication information shall, so the warrant itself, shall require that any information obtained through the execution of the warrant that is unrelated to the objective of the warrant be destroyed within 30 days and not subject to further review, use, or disclosure. Shall not apply when the information obtained is exculpatory with respect to the targeted individual. So, if we're talking about the 30 days issue, that's great, and there's nothing magic about 30 days, of course. We can certainly work with that. But the idea, the intent of subdivision 2 is that when the warrant is executed, a lot of stuff gets gathered up. Much of that or some of that is going to be unrelated to the purpose of the investigation. Again, this is an effort to treat our personal, private information, data, documents, whether it's physical material or electronic material, as we would under the provisions of unreasonable search and seizure provisions in our Constitution.
One question, Superintendent, that I had is when law enforcement is seeking information data after, let's say, after 180 days. How do they access that without a password or a username? How would they get that?
Mr. Chair, members, if we're referring to, just as an example, from Facebook or email, in those situations, the electronic service provider, remote computing service, they have access to that data even without the search warrant. So the search warrant is written to the company, and the company is the one that produces the data in that situation.
But after 180 days, the search warrant is not necessary under existing law. So is it just a request from your agency or a police agency?
So, Mr. Chair, members, as I noted, we are not accessing it in that manner. We are getting a search warrant. However, as I noted, I had the statute up. There are some requirements in 626A. If you provide notice to the customer, if you do not provide notice to the subscriber or customer, you need a search warrant. However, under 626A.28 subdivision 2, if you prior notice to the individual or the customer, you can get that through an administrative subpoena authorized by statute, a grand jury subpoena, or a court order that's outlined in subdivision 4. And what you need to note is that it's legitimate to an ongoing criminal investigation.
All right. Senator Anderson.
Thank you, Mr. Chair. Back to, I guess, the 30 days, but it says here, require that any information obtained that is unrelated be destroyed within 30 days. Who makes the determination of unrelated material?
Senator Dibble.
Mr. Chair, Senator Anderson, looks like Senator Ralph had the same question. Well, that of course would be, again, probably the law enforcement authority themselves would have to make that determination for themselves. I don't think there's anyone sitting on their shoulder, but hopefully they understand the provisions of the law. Does that answer your question?
Well, Mr. Chair, Senator Dibble, I think that it would be in the eyes of the investigator and those people who are at the scene of the accident or the crime or whatever the case is, and then to say this is unrelated, yeah, I guess maybe you're saying that person then has to make that decision, but then his superior or somebody else has to say, okay, we agree with you. That it's almost like you got to have a huddle to come up with the decision-making process of this. So, it seems maybe, like was mentioned by several testifiers, some of this language is a little broad.
Senator Dibble.
I would respectfully disagree in this instance. I think it would be quite a governmental overreach and a law enforcement overreach to be able to basically go in under the pretext of probable cause on one matter and then go in and grab up a bunch of stuff and then just hang on to it for the purpose of conducting fishing expeditions. I mean, that's the whole point of the bill, is that we not have law enforcement probing our electronic data without some threshold or standard, whether it's a warrant or subpoena or something like that. And it's, to a specific purpose with a specific matter in mind. It happens all the time. Warrants are executed, all kinds of stuff gets gathered up, trucked away, and, some small percentage of it has anything to do with the actual potential crime that's being investigated. The rest of it is disregarded and either destroyed or returned. And this is simply would treat electronic data, private property, in the same fashion. I did want to mention, back up to a previous comment, and that is, having the need for administrative subpoenas or grand jury subpoenas or the like. Keep in mind when subpoenas are invoked as the threshold and or the permitting authority or document that allows for an examination of our private documents, our private property, that's a pretty low threshold. Again, it's basically on the authority of the investigator themselves to issue that subpoena and then go take those looks. So when you hear about, we don't go and look at emails that are older than 6 months without an administrative subpoena. That basically says we give ourselves permission to go look at emails that are older than 6 months.
All right. Senator Ralph, last question.
Yeah, now, with respect to that, it seems to me that, and I think Mr. Evans can probably comment, that most search warrants try to be fairly narrow in their scope. And the issue becomes, with this massive electronic data, is actually being able to sort through it to find out whether it is within the scope. And I think that's the issue here, and the period of time is more of concern to me than the fact that ultimately we are going to and I believe that the idea here is to allow the enforcement to do the job, but to not allow them to expand the scope of the search warrant without coming back and asking for more, for permission. So.
Senator Dibble.
Couldn't have said it better myself, Mr. Chair. Thank you, Senator Ralph.
This bill will be laid over for possible inclusion in the Omnibus Data Practices Bill. There's no further business. We stand adjourned.
Oh,